According to the Sentencing Council, judges and magistrates must follow 10 steps when sentencing an offender. These are: Step 1. Determine the offense category. Step 2. Identify the appropriate starting point and range for the category. Step 3. Aggravated offenses. Step 4. Give a reduction for assistance. Step 5. Make a reduction for a guilty plea. Step 6. Consider the dangerousness of the offender. Step 7. Apply the totality principle. Step 8. Consider any compensation and ancillary orders. Step 9. Give reasons for the sentence. Step 10. Make a reduction for any time spent on remand. Sentencing guidelines will set out the offense categories for a particular offense. This will involve looking at the level of culpability of the offender and the seriousness of the harm caused. For example, the sentencing guideline for Section 18 wounding and GBH has 3 categories. Category 1, the most serious, includes injuries which are particularly grave, life-threatening or requiring lifelong dependency. Category 2 is for grave injury or permanent injury not falling in Category 1. Category 3 is for all other injuries not falling in Category 1 or 2. For each category there is a subcategory of A, B and C reflecting levels of culpability. Subcategory A has the highest level of culpability for things such as premeditation, a vulnerable victim or use of a weapon. Subcategory C is for lesser culpability. For example, where an offender was acting in self-defense or as a result of provocation. Once the offense category is determined, the sentencing guideline sets a starting point and range. For example, for the Section 18 offense, Category 1A has a starting point of 12 years with a range of 10 to 16 years. Whereas a Category 2B has a starting point of 5 years and a range of 4 to 7 years, and a Category 3C has a starting point of 3 years with a range of 2 to 4 years. The courts look at aggravating and mitigating factors to determine what sentence should be imposed. Aggravating factors such as previous convictions, premeditation indicating a longer sentence, and mitigating factors such as remorse and good character decreasing the sentence. This step only applies to offences under Section 29 of the Crime and Disorder Act 1998 where an offence has been found to be racially or religiously aggravated. This step considers the degree to which the offense was racially or religiously motivated, either high, medium or low, and provides for a sentence uplift accordingly. Section 74 of the Sentencing Act 2020 provides that the court should consider a reduction for any assistance given to the prosecution. The court may reduce a sentence by up to a third where the defendant pleads guilty. Section 73 provides that the court must take into account the timing of the guilty plea. The court must assess the dangerousness of an offender under Chapter 6 of the Sentencing Act 2020. If the court is of the opinion the offender is dangerous, they need to consider imposing an extended sentence under Section 279. An extended sentence is where the offender is released on license after serving their custodial sentence and is monitored in the community. When sentencing an offender for more than one offense, the court needs to apply the totality principle. The overriding principle of totality is that the overall sentence should reflect all of the offending behavior with reference to overall harm and culpability, together with the aggravating and mitigating factors relating to the offenses and those personal to the offender, and be just and proportionate. The court should consider where it is appropriate for sentences to run concurrently or consecutively. The court must consider compensation and ancillary orders. If the court decides not to give a compensation order, Section 55 of the Sentencing Act provides it must state reasons for not doing so. Step 9. Reasons. The court must declare the reasons for reaching a sentencing decision in open court under Section 52 of the Sentencing Act 2020. Step 10. Reduction for remand. The court must reduce the sentence for any time served on remand. A reduction may also be made in respect of any time spent on curfew or electronic tagging whilst out on bail. In summary, sentencing of offenders is a rigorous process in which judges and magistrates are subject to strict guidelines. This should allow them to impose a fair sentence and tailor the punishment to the particular crime and ensure a degree of consistency in sentencing. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.